excellence.
Yes, you are watching Face to Face, this time from our new set at the studios of Twin Cities Public Television. Rick, I'm really going to enjoy this show because we're going to talk about the growing split between libertarians and social conservatives.
Oh, David, I know you're going to enjoy the show, but I will too. You know, the founders recognized that the exercise of liberty requires a moral compass, but liberty today seems to mean sodomy, gay marriage, and medical marijuana. Libertine liberties and more, next on Face to Face.
Production of Face to Face is brought to you by the law firm of Robbins, Kaplan, Miller, and Cerisi, LLP, a national law firm representing the legal interests of businesses and individuals in Minnesota and across the country. TCF Bank, your hometown bank with convenient full-service banking offices and express teller ATMs located throughout the Twin Cities and all of Minnesota. TCF Bank, member FDIC. The Target Corporation is proud to give over $1 million a week back to the community. Providence Academy incorporates faith formation and character development with premium academics for the education of a lifetime. Visit our website at www.providenceacademy.org for more information.
Welcome to Face to Face. I'm Rick Morgan. Along with my co-host David Lillehog, we're going to be exploring the implications of recent court decisions that have discovered in the Constitution rights to private homosexual sodomy, gay marriage, and at the same time, courts in California are wrestling with the issue of whether liberty extends to the use of medical marijuana. Here to help us parse these issues are two eminent legal thinkers. First, Professor Randy Barnett of the Boston University School of Law and a senior fellow at the Cato Institute, and also the author of a new book, Restoring the Lost Constitution, The Presumption of Liberty. Also joining us is Tom Prichard, the president of the Minnesota Family Council and an attorney here in the Twin Cities. Welcome to you both. Welcome to Face to Face.
Thanks.
So we have this revolution at the Supreme Court this past year, Professor Barnett, where the Supreme Court has found a liberty interest in private homosexual conduct.
Well,
how remarkable is this?
It's a potential revolution if the court follows up on this case in the future. But what makes it revolutionary is that it's protecting liberty without finding first that the liberty in question is a fundamental right.
Before that, I mean, nobody would have argued that private homosexual conduct was somehow a fundamental right.
And they wouldn't, and in fact, the court doesn't find it to be a fundamental right. That what makes this case significant is in the old doctrine, the fundamental rights doctrine, before you get to shift the burden of proof to the legislature to justify its laws, you have to find the liberty to be fundamental. Under this new doctrine, hopefully revolutionary doctrine, this legislature has to justify what it's doing without the liberty being found to be fundamental.
Why is this such a good thing? You sound enthusiastic about it. Why should we be standing up and cheering for something like this? Obviously, a lot of people are grossed out, frankly, by the decision.
Because in our society...
That's a legal term, grossed out.
In our country, we have a choice to make. Do we put the benefit of the doubt on behalf of the individual and the individual's choices, or does the benefit of the doubt go to the legislature and what the legislature does? In a system of limited government, the benefit of the doubt should go to the citizen, which simply means the legislature should have to justify what it's doing. Under fundamental rights jurisprudence, it doesn't have to do that unless the liberty can be characterized as fundamental, and that's often hard to do.
Now, Mr. Prichard, I know the Minnesota Family Council doesn't think private homosexual behavior is a fundamental right. And in fact, my understanding is back in 1999, you testified against repealing the sodomy provisions of Minnesota law that actually make it a crime in the state for anyone, homosexual or not, to engage in any kind of oral sex or anal sex. Do you really believe government should extend that far?
Well, I think there's two questions in this case. First of all is what is constitutional, and obviously that's the problem with the Lawrence decision is they're saying it's not constitutional to make these laws. But I think there's obviously a reasonable basis for having such a law because it basically stigmatizes certain behaviors which are destructive and harmful. So I think it's a very legitimate power. Obviously it's not enforced, but I think the big problem with the Lawrence decision is basically what they've done is codified the sexual revolution and put it in the Constitution, and they've really distorted the whole notion of liberty now. They've taken a good concept and they've thrown it up in the air, basically.
Well, if I understand your position from a constitutional standpoint, speaking only hypothetically,
sure.
Let's say I decide to have oral sex with my wife in the privacy of our home. Are you saying there's nothing in the Constitution that does or should prohibit the state from prosecuting me for a crime?
Well, I think basically, if you don't like that law, you should get rid of it. If lobby at the legislature, they
Yeah,
should
but you're
repeal
lobbying
it.
against it.
Well, that's our prerogative, and I think that you look at what is one of the primary means of transmission of many sexually transmitted disease, the AIDS epidemic. Well, sodomy. Same thing with illicit drug use. I think those are obviously legitimate areas to legislate, but I think the big concern we see with the Lawrence decision is they're going even far beyond that to basically protect any sort of sexual activity.
Professor Barnett, and you've worked on the Texas sodomy case, at least in an amicus capacity, and one of the things that was discussed in the decision was how did the Texas legislature justify on a rational basis its decision to outlaw private consensual sodomy. And they tried to justify that. We've heard a health basis, which is often the basis for so many of these morally driven laws. What was the finding of the court?
Well, not the finding of the court, but what the court did is it shifted the burden to the legislature, as I said before. So now the legislature had to come forward with a rationale for it, which otherwise it wouldn't have to. And it didn't offer the health-based rationale or justification for it. It offered one justification, that in the opinion of a majority of state legislatures, the actions in question were immoral. That was the sole justification offered by the state.
Would they have had a better shot if they had argued health issues?
They would have had it would have been a much more difficult decision for the court to make had they argued health issues. But I wonder why, as a political matter, they chose not to. And they did choose not to.
Because the argument can be made that there are health issues associated
Right.
with those kinds of sexual behaviors that are harmful.
So the question really presents itself, why, as a political institution, did the executive branch or the legislature not argue that? They didn't argue that. That's not the case before the court.
Let me get this straight with regards to the Lawrence case. You go back to the Griswold case, which found a right of privacy so that married people could use contraceptives in the privacy of their own home. Are you telling me that the Lawrence decision really doesn't follow that at all? It goes off on an entirely different track?
Well, it's different in one respect. The Lawrence case does not protect a right of privacy. It does protect liberty. In fact, it only mentions the right of privacy 4 times in the context of discussing Griswold. It mentions liberty 25 times, not counting the times it mentions the word freedom. So it is a different basis for the decision than in Griswold. And I should also remind you that Griswold concerned not only the total, complete, private, behind the bedroom door conduct, but also a statute that prohibited the sale of contraceptives. That economic liberty was also struck down as unconstitutional in Griswold.
Okay, and let me understand for you, Mr. Prichard, what your constitutional provision is. Do you think the state legislature and the governor have the right to pass and sign into law a law that would, for example, make it a crime for married couples to use birth control?
Well, I think there's 2 questions there. One is that an appropriate law to make? And I'm not advocating that law, but I think the other issue is a constitutional question. Should they have the right to make that power? And I think what you've seen with this whole liberty notion and privacy, we've seen abortion, finding a constitutional right to abortion. Here in Minnesota, you have taxpayers having to pay for abortions because they've created this right to abortion. And I think what they've done here is basically just substituted the word liberty for privacy, and they want to have it sounds a little better. And I think that we've got the same problem is you're putting power, pretty much unlimited power, in the hands of a few judges to set the moral standards for the whole country. And that's really the definition of tyranny.
Well, in fact,
so often in our history, we've had a balance between the legislature reflecting the moral wishes of the majority and then the Constitution and judges fighting against that. Doesn't the concept of liberty as enunciated in the Lawrence decision threaten to really put the legislatures out of business when it comes to reflecting the moral values of the majority of citizens?
Well, not at all. Judges don't legislate. Judicial...
Oh, please. Of course.
I mean, no, judges, I'm not saying judges never do, but this is not an example of that. Judicial negation is not legislation. The judge is saying no because they're the 3rd branch of government that has to concur in the constitutionality of a particular statute. Is not the same thing as the judges being able to, by themselves, enact a particular law that permits or doesn't permit certain actions to take place. They have to do so only in conjunction with the legislature. In this case, what we have a choice between is a presumption of constitutionality, which gives the benefit of the doubt to the legislature, except for a few privileged fundamental rights, or a presumption of liberty I defend in my book, which gives the benefit of the doubt to the individual unless the legislature can meet a burden of justification, which it failed to do in Lawrence.
Tom has mentioned the potential breadth of this. How does it go as far as extending to laws that now prohibit incest or adultery? To what extent is the sexual revolution going to be codified into law because of the liberty concept?
This particular opinion is quite limited to activities that don't even arguably harm anybody else. Any actions that arguably harm anybody else, we really are in a different ballgame. And as a predictive matter, I believe the court would come out differently on such matters.
How do you see that, Tom?
Well, I think that's absolutely, it's far beyond just the issue of sodomy. If you look at Scalia's opinion, he says this opens the door up to, and you see it in the gay marriage issue. They're pushing gay marriage and all sorts of things.
And Tom, we're going to open the door to Justice Scalia and find out why your organization has called
First.
Yeah, well, yes, it was discombobulating to say the least. Apparently, your organization does a 2-minute radio spot on some radio station that I think is a little better than a ham radio. And one of the scripts regarding the Lawrence case that we were just talking about attacked, quote, liberal judges who are godless and destroying our nation, and said they're responsible for the Lawrence decision. Now, do you really believe Sandra Day O'Connor and Anthony Kennedy are godless liberal judges?
I think the issue there is morality, and where does our morality derive from? And there's a attack basically on public morality, saying that just because there's a morality basis for these decisions, they're illegitimate.
So if I disagree with you on morality, then I'm godless. Does that follow?
Well, I'm not saying you're godless.
Well,
but
you're saying those judges are godless.
Well, I think the philosophy that's emanating from there really throws out the notion that there is a creator, we're endowed by our creator with certain unalienable rights, nature's law, God of nature, the Declaration of Independence. Those are ultimately where these issues are rooted, or the foundation for these laws.
I think it's fair to say our current jurisprudence, David, presumes the absence of God, and I think to say otherwise is ridiculous.
I think that's absolutely silly. There are many people that have views of the Constitution that you may disagree with, and I know Mr. Prichard disagrees with, who are very religious people and feel their views are religiously based. Isn't that true, Professor?
And there should be a discussion of those issues in legislative bodies, and that should lead to legislation. But that's not happening now because of the liberty interests.
I'm a strong proponent of natural rights. In fact, my first book, The Structure of Liberty, was all about natural rights. And the conclusion of a natural rights analysis is, and this is from the founding forward, is that individuals come first, and the state are simply the agents of the individuals, and when the state presumes to tell individuals what to do, the burden should be on the state to justify what it's doing. Now, that's a product of a natural rights analysis. That doesn't violate it.
Speaking of natural, you're representing the Oakland Cannabis Cooperative. Do you support the medical use of cannabis because it's natural, or how do you come to that position?
Well, the position that we are arguing in our case, and we've won one of these cases in the Ninth Circuit, is that the court ruled for us on Commerce Clause grounds. It's beyond the power of Congress to reach wholly into a state and regulate wholly intrastate activities, which has been legalized by the state of California. We think this is a violation of fundamental federalism principles, and the Ninth Circuit has agreed with us.
Oh, I love it. John Ashcroft opposing states' rights.
And
you can't make that up.
He has.
Yeah, you're in favor of that law, and the Minnesota Family Council is too, I'm sure, aren't you?
Oh, we think it's certainly legitimate. We've opposed efforts to legalize marijuana, medical marijuana. We think it's a gateway drug, and we shouldn't be promoting it.
But if a state chooses to legalize medical cannabis, you wouldn't want the federal government interfering with that state's choice, would you?
Well, I think it's up to the federal government. Obviously has broad powers, have expanded over the last generation, and if You know, it's up to the...
That's just absurd. I mean, the federal government, through the FDA, regulates all sorts of schedules of different types of drugs. And there's no consideration that, for example, if the state of California wishes to make Valium, or what's Rush Limbaugh's favorite, Vicodin, a drug that can be sold, just made and sold interstate without any interference from the federal government, I don't think anybody would agree with that. Why can't the FDA regulate marijuana as a scheduled substance and regulate it that way?
They can regulate it. The question, and when it's marketed, the question is whether they can prohibit it when it's homegrown. The FDA does not presume to govern homemade remedies of one's own confection. It doesn't presume to cover that. When the FDA was passed,
so if I make methamphetamine in a lab in Oakland and it's purely homegrown from ingredients I did, are you saying the federal government can't bust me?
And it would be solely for your own consumption as opposed to being used and distributed, which is what those meth labs do. Once it's used and distributed, it becomes a commercial activity. Then
the grower sells it to the patient. It's distributed, sir.
Well, there is a question in one of our cases as to whether a wholly owned cooperative, of which there are patient members, is really a sale or not a sale. But even if it is a sale, if it's a wholly intrastate activity, then it may be beyond the...
I make methamphetamine at my home. I sell it to my neighbor. Purely intrastate. I've distributed a scheduled narcotic. Under your analysis, the federal government couldn't bust me.
They could only have jurisdiction if you could show that the aggregate effect of that intrastate activity has a substantial effect on interstate commerce. That's the ruling of Wickard versus Filburn, the 1940
and the extension
New Deal case.
The extension interstate has been the basis of a lot of civil rights legislation. How do you avoid hurting those things?
Here's the point. We have a government of limited and enumerated powers, and the drug war should not be used as an excuse to eliminate the basic fundamental principle of limited government on which this country was founded.
Speaking of fundamental, let's let Mr. Prichard
I think
respond.
we have to ask the professor, where does this stop? Heroin use, crack cocaine use, LSD use, are these now protected by this notion of liberty? I mean, that seems to be where you're going with this.
No. Well, just because the federal government can't reach it doesn't mean states can't reach it. In California, we're talking about a situation where the state has decided. In fact, the state is an amicus argument on our behalf, and our clients in the Oakland case are the authorized distributors representing the city of Oakland. So we're talking about the police power of the states being used to legalize something, and the federal government, which disagrees with the policy choice made by the people of the state of California in popular initiative, is trying to override that principle.
Are you finding now a constitutional right based in liberty to engage in drug use if it's in the privacy of your home, whether heroin, crack cocaine, or other things? Would you support that?
Getting back to the first segment that we discussed, the issue is whether if you are engaged in a liberty which does not harm others, the burden of proof then falls upon the legislature to show why its regulation is necessary and proper. Let it do so. If it can't do so, then the activity of the individual should stand.
Do you personally think those should be protected by the Constitution, liberty?
I believe all liberty is protected by the Constitution.
But if it affects those sorts of drug use?
That's a form of liberty, yes.
Okay.
I mean,
I think we're going too far.
Let's leave the drug war and go to something non-controversial, which is gay marriage. Now, one of the implications of Texas versus Lawrence, of course, is reflected in the Massachusetts Supreme Judicial Court's decision in the Goodridge case, which by a 4-3 margin said even civil unions for gay and lesbian people is not adequate. It needs to be called marriage. You're now teaching in Massachusetts. Must be a very hot issue there.
It's a very hot issue. I don't discuss this in my book, and the reason I don't is because what's at issue in gay marriage is not a strict liberty of the individual to do or refrain from doing something. It's not a matter of the state prohibiting people from doing something. It's a matter of whether the state has a basis for giving a privilege to one group that it then refuses to give to another group. That is a straightforward equal protection argument, and it's not the thesis of my book. It's not what I talk about. I'm not saying it's not important. I'm just saying it's not, what we have is the extension of a privilege rather than the violation of an immunity.
But they relied on Lawrence in that case.
They did.
And here you have a situation where the amicus briefs in the Lawrence case said there's a difference between regulating private morality in the home and public morality, and in the brief you were engaged in, talking about the fact that public morality would include things like polygamy, adultery, and here we have the most public act a couple can engage in, which is marriage. It intersects the public interest in so many ways. This is not a private issue. How do you analyze that under your liberty
Well,
analysis?
it's not public in the sense we said in our brief. Public in the sense of, for example, public fornication, in which things are happening in the public areas that inhibit the ability of the public to use those areas. But what it is not a liberty, it's not a restriction of liberty per se. Marriage is the dispensation of a benefit. It's a mark of social approval of a particular relationship. And then the question is whether, having approved this form of relationship, it is rational to deny that form of relationship to another, that form of approval to another relationship, and that's really a different kind of argument.
Oh, I think characterizing marriage as approval by the state really goes too far. When Brittany and her old boyfriend go off to Las Vegas and get married, the state's not approving of that. It's simply establishing a structure and giving people freedom to operate within that structure to build the kind of relationships that they want. Why shouldn't gay people and lesbian people have that same right?
Why not, Tom?
I forgot. No, they're the liberal, godless judges that are pushing this, right?
Well, I think that fits in this case.
Well, I think there's a fundamental interest of promoting marriage between a man and woman. You can't fundamentally redefine it. That's the nature inherent in marriage, that children, one of the fundamental is procreation, aspects of marriage is procreation. Children need a mother and a father. I think the state has every interest in promoting marriage between a man and a woman. And it shouldn't be in the hands of the judges to decide that for us.
Oh, hold on a second. The Minnesota Family Council is not saying people who are, for example, past menopause shouldn't get married because there can be no procreation there.
Well, there's potential in terms of adopting children, raising children there.
Well, yeah,
and also, I think
lesbian couples can adopt and raise children also, except in Florida.
But inherent in a gay-lesbian relationship is a lack of a mother or father. And basically, you're saying that one of those people is not important. We say they are fundamental. The breakdown of the family, of marriage, is the source of all sorts of social problems.
Is there a social interest in having a special union that bridges the gap between men and women? Is that an issue?
Well, I think there is. The question really is whether the benefits of marriage are limited to that particular benefit, or whether those benefits would also, the relationship of marriage would also benefit people of the same sex.
And why shouldn't the legislature decide that, rather than 4 judges on the Supreme Court of Massachusetts?
The legislature can decide that if they have a rational basis for distinguishing between the two relationships. That's the question. I want to make clear, I'm not opposed to gay marriage. I really have an open mind on the subject, but I do think that the distinction, that the legal issue is different.
Well, now, are you saying that the legislature can act, but should there be a federal constitutional amendment where legislatures are prohibited from acting?
Well, I support the federal amendment. I think the institution of marriage is so foundational to the well-being of society that I think it is, and as you see, the federal judges, state judges are getting out of control.
And what's foundational to our well-being is getting off the air when the crew tells us to. But we'll be right back with the face-off, so don't touch those remotes. Stay tuned to Face to Face.
We'd like to hear your thoughts about the show. Comments may be directed to comments@facetofacetv.com or send a letter to Face to Face, 800 Nicollet Mall, Suite 2680, Minneapolis, Minnesota 55402.
Welcome back to Face to Face. Log on to www.facetofacetv.com and vote in this week's poll. Do you agree with the Supreme Court's decision in Lawrence v. Texas? We look forward to your votes, and we also look forward to your comments about the show. Well, David, this past week, Governor Pawlenty gave his second State of the State address, and the Taxpayers League was ecstatic about it. I wonder how it looked from your vantage point.
Well, once again, he was beating the death penalty constitutional amendment idea, which is just absolutely silly because we've had capital
punishment. It would let the people decide.
Well, we've had capital punishment in the state before. If he wants to reinstitute capital punishment, then have the legislature pass a law, and we can deal with it that way. But it's really a very transparent transparent device to try to increase Republican turnout in the upcoming legislative election.
I think it's a useful debate to have. I think the death penalty is something that a lot of people are concerned about. I think in light of some of the really horrific crimes we've had, it's something that's worth addressing. It's going to be very interesting to see if we actually have a federal death penalty case here in the next year. That's another possibility. Do you see that happening?
We may well. Boy, that process is taking a long time. This relates to the alleged robbery of an armored car in which there was a shooting, and the U.S. Attorney and the Attorney General have an interesting decision to make here in Minnesota.
Another process that's taking a long time is the race for the Democratic nomination.
Long time, it's almost over.
Is it almost over?
It's
Are you saying that Howard Dean and Wesley Clark are no more?
Well, you know, Will Rogers used to say, I don't belong to any organized political party, I'm a Democrat. And my goodness, the Democrats are getting organized. They are rallying around the prospective nominee, and boy, I think your guy Bush, he didn't look good at Meet the Press. He's going down.
I'll tell you one thing, David.
You can't tell me anything more. We'll deal with it next week on Face to Face.
We'll get you next time.
Production of Face to Face is brought to you by the law firm of Robbins, Kaplan, Miller and Cerisi, LLP, a national law firm representing the legal interests of businesses and individuals in Minnesota and across the country. TCF Bank, your hometown bank with convenient full-service banking offices and express teller ATMs located throughout the Twin Cities and all of Minnesota. TCF Bank, member FDIC. The Target Corporation is proud to give over $1 million a week back to the community. Providence Academy incorporates faith formation and character development with premium academics for the education of a lifetime. Visit our website at www.providenceacademy.org for more information. Additional support is provided by Abelcon, Microcontrol Systems, and Investment Management Incorporated.
Broadcast of Face to Face is supported by Twin Cities Business Monthly, committed to delivering business excellence.
Tonight, it's a great evening of entertainment starting at 6 with Andre Rieu live in Tuscany. Then at 8, Louis Anderson will be live in our TPT studio to host an encore of his 1987 Guthrie Theater performance that jump-started his career. Then at 10, 60,000 loyal Phish fans trek to Maine for America's Greatest Jam Band on It, a Phish concert special, tonight on TPT2.
Hi, it's Louis Anderson. 17 years ago, I shot Louis Anderson live at the Guthrie, and that show changed my life. It's all about mom, dad, brothers, sisters, and Minnesotans. And you're going to see it live with me. I'm going to be in the studios. Don't miss this show. It's going to be great, and it was all done right here in Minnesota.
You know what I mean? Getting hit right in the ear with an ice ball. Oh!
Tonight at 8 on TPT2. Don't miss this.
Public television brings back the magic moments from the 1950s.
Sincerely.
The McGuire Sisters, Pat Boone, Patty Page, Debbie Reynolds.
Wednesday at 7.
Sunday's broadcast schedule is supported locally by TPT members and by Rotland Homes and Rotland Townhomes, innovators in design and lasting value since 1973. Your builder for life in the Twin Cities. The Business Journal, breaking local business news every week. And by American Medical Systems, providers of medical devices for treating incontinence, erectile dysfunction, and prostate disorders.
Thanks to viewers who have donated vehicles to TPT. You can support TPT by donating your car, truck, or van. Your contribution is tax deductible. For more information, call 651-229-1530 or visit us at tpt.org and click on Donate Your Car. Don't miss an evening of romance, magic, and beauty on Andre Rieu, live in Tuscany.